All rise.
My lords, my lady, I was turning to Mr. Owen's note from this morning where he set out his proposed proviso to Section 1. Could I make 2 points in relation to it? The first is that it is incorrect to regard the Section 1 power as a simple transposition power. We say that for 3 reasons. Firstly, that Security Council resolutions themselves are not the result of a legislative process.
Sorry, can you just speak up a little?
I'm sorry. Yes. Firstly, that Security Council resolutions themselves are not the result of a legislative process. Rather, they are the result of a process of discussion and negotiation between members of the Security Council. Secondly, once the resolution has been agreed... I
just don't understand. Well, are you going to explain them in a minute when you...
I'm sorry,
I just don't understand why the fact that they're the result of discussion means that this is not a transposition power.
My Lord, simply because they are not formulated by the way of the same process of legislation. And the whole transposition argument, I assume, must presuppose that what comes from the Security Council is, as it were, a pre-packaged piece of legislation that can simply be slotted into the domestic regimes of all member states.
But doesn't that point make it even more of a transposition exercise rather than less? You've got to turn it into something that is a...
Yes.
Something like legislation.
Well, my Lord, yes, but I think the sense in which Mr. Fordham was using the notion of transposition was simply that it was an exercise, as it were, of cutting and pasting.
Well, no, I understood him to... It's a word that's very commonly used for giving effect to European Union directives in domestic law. I understood him to indicate that sort of exercise.
Well, my Lord, if that's the basis on which his submission is made, I would suggest it adds nothing to an exercise of attempting to distinguish between certain types of decision under Article 41 which are capable of being given effect in English law by Section 1 and others which are not.
Well, to take a particular example, when it says commit in paragraph 1c,
yes,
freeze without delay the resources of persons who commit terrorist acts. Are you saying that that can be read as if it didn't mean what it says, that it can be expanded in some way to those who might be reasonably suspected of having committed?
My Lord, we say it can be read in that way. And this is the second point, that in terms of the effect of international obligations, the obligation of member states is to interpret and apply those measures in good faith. And we say, and I'll make this submission in more detail in a few moments, that when one looks at Resolution 1373 as a whole, it is a strongly preventative measure. When one sees also the connection between Resolution 1373 and the connection with the resolutions that started with and have followed Resolution 1267, another preventative scheme, that underlines the point. When one also sees the expert guidance that has been given internationally as to the approach member states should take under 1373, that again underlines the preventative approach that should be taken and the adoption of a standard of reasonable suspicion. And finally, when one looks at the provisions of Section 1 of the Act itself, the scope of the power is to make provision necessary and expedient to effectively apply the measure of the Security Council. And so one sees there the link between the initial obligation of the member state to interpret and apply and determine its obligation in good faith, and then the extent of the power within domestic law to be able to reflect that good faith interpretation through the particular provision, in this case, the terrorism order itself. My Lord, I think that concludes what I wanted to say about a transposition power. With regard to
It sounds from that argument you ought to be cross-appealing in relation to the excision of May.
My Lord, with respect, no. Well, we don't cross-appeal in relation to May.
But why not?
You don't really need it, do you?
Well, firstly,
if you've got reasonable suspicion, you don't really need May.
Yes. My lady identifies immediately the strong practical reason why there is no need for an appeal. But perhaps dealing with my Lord Phillips pointed at a higher level, and not for a minute to dismiss the practicalities of matters, but at a higher level, clearly there will in practice be a necessary relationship between the scope of the domestic measure and the enabling power itself, which is here to make provision necessary expedient to effectively apply. There have to be limits to that notion within the language of Section 1 itself. This was a point that was made specifically by Lord Justice Wilson in his judgment. Perhaps I could just give you the reference and then paraphrase what he said. It was at paragraph 155 of his judgment, and that's in volume 9 of the authorities at tab 69. The gist of what he said was that, and this was in relation to the inclusion of the word expedient, was that the power to make expedient provision was itself confined within the contours of effective implementation. I think that was the phrase he used. And on that basis, that the validity of the order was to be judged by reference to whether its provisions were necessary and expedient in relation to the objective of achieving effective implementation of the measures. Now, in practice, there will always be limits to how far the executive can go, consistent with those legislative words. The conclusion reached both by Mr. Justice Collins and by the Court of Appeal was that the inclusion of the words "or maybe" was beyond that limit, and on reflection, that was a decision that was accepted by the Treasury. My Lord, the second point we take in relation to Mr. Owen's formulation is that as for the remainder of it, it simply has no basis in the language of Section 1 itself. Again, we place reliance not only on what is in Section 1 of the Act, but what is not in Section 1 of the Act. And the various criteria of identified targets determined and identified by the Security Council, and which the international community is required rapidly and uniformly to apply. None of those matters are criteria which exist within Section 1 of the 1946 Act. It would be, we say, entirely inappropriate to read down Section 1 in that way. That exercise would itself clearly fall on the legislative side of construction, not the construction side of construction. Perhaps by contrast, in the course of argument yesterday afternoon, my Lord Hope suggested to Mr. Owen that the starting point for his proviso might be the language of Lord Brown-Wilkinson in Ex parte Pearson, which was effectively the statement of the principle of legality. Now, that, of course, would be, firstly, an entirely acceptable proviso, but would be a proviso that existed as a matter of common law in any event. And so, to some extent, one might say, well, one doesn't actually need to enunciate that proviso separately. However, based on the submissions we've already made this morning, we say that if one applied that standard of legality to this exercise of the Section 1 power to make the Terrorism Order 2006, there can be no question but that the Terrorism Order passes that test. My Lord, the final argument on construction that was advanced, both by Mr. Owen and Mr. Fordham, was based on the notion of legislative design. With respect, we say that is simply not a concept. Well, firstly, the Treasury does not recognise it as a legal concept, but certainly it's not a concept that can be derived from the 1946 Act itself. Again, the language of Section 1. Either it has to be a notion that there is some form of requirement on the Security Council when formulating measures to meet some unidentified standard of legislative design. Now, that's not a notion to be found anywhere in the Charter itself, and one might ask, how could it possibly be enunciated in the Charter, given that, if it were, the Security Council would need to meet the legislative practices and traditions of many member states before it could ever take an effective Article 41 decision. If, by contrast, this notion of legislative design is meant to attach to the process under Section 1 itself, the process of making provision, well, clearly that is something that is expressly anticipated by the words of Section 1. Again, when they refer to provision, such provision being made that is considered to be necessary or expedient, etc., that is precisely the process that one sees when an order under Section 1 of the Act is made. Perhaps by way of example of that, in the course of yesterday and also in the course of this morning, reference has been made to the sanctions that were applied against Rhodesia in the 1960s. We have copies in court both of the Security Council resolution and the order made under the 1946 Act, and perhaps I could just give those to you and make a few brief points. My Lords, before I do, could I just, for completeness' sake, make one point? In relation to the applications of the sanctions within Southern Rhodesia itself, a further order was made under the South Rhodesia Act of 1965. The reason that there was a need for a further act insofar as the measures applied within Southern Rhodesia itself was that in Section 1 of the 1946 Act, as originally drafted, the power to make provision in respect of the dominions, including Southern Rhodesia, was excluded. And so, to that extent, there was a parallel scheme to apply the same matters within Southern Rhodesia itself under a different statute. But, my Lord, that is for completeness' sake, and none of that detracts from the points I'm about to make as to legislative design. First, could I ask you to look at the resolution, which is Resolution 253 of 1968. And in particular, paragraph 3 of the resolution on the second page, which has page number 6 at the bottom, the decision that all states shall prevent, and then one has the import of all commodities originating in Southern Rhodesia, in A. In B, any activities which would promote or are calculated to promote the export of commodities or products from Southern Rhodesia. In B. In C is the shipment in vessels or aircraft, or the transport by land, of any commodities originating in Southern Rhodesia. D, the sale or supply by their nationals or from their territories of any commodities or products to any person or body in Southern Rhodesia, or any other person for the purposes of business carried on in or operated from Southern Rhodesia, and to D, the shipment in vessels or aircraft of any such commodities or products which are consigned to any person or body in Southern Rhodesia. That is the resolution itself very quickly. Turning to the order, the provisions of paragraph 3 of the resolution are implemented primarily in Article 7 of the order. And one can see there, to an extent, as it were, a process of formulation of the measure contained within the order in order to give effect to it within domestic law. But could I ask you to look at Article 9 of the order, which is page 5 of 15, using the numbers at the top of the pages. Now, within Article 9, one sees the creation of very extensive powers to arrest, hold, or direct the passage of ships and aircraft, and including authority for the use of reasonable force. Now, those measures clearly created in support of the Article 7 prohibitions, but clearly they are detailed and thought through measures, and to the extent that there is, as it were, a need to apply legislative design, one sees that design being applied in the process of using the power under Section 1 of the 1946 Act. I'd also ask you to note within Article 9 itself that the powers themselves, both, as it were, the peremptory powers in terms of boarding ships and searching ships, and the longer-term powers, such as those to require, or rather, yes, to require a vessel not to land at any particular port, or require any of the measures specified in A to D of Article 9.1 to be undertaken. Each of those measures is a measure that is exercisable on the basis of reasonable suspicion. And I would suggest and submit that the reason that is the appropriate standard in the context of this particular order, again, is the clearly preventative purpose of the sanctions that were required to be applied by the Security Council.
You don't get anything explicit in the Security Council resolution on those matters,
No.
do you? But then you could say that is covered by the phrase in Section 1, including provision for people offending against the order.
Yes.
And these people would be offending against the
My
order.
Lord, they would. With respect, that's where one gets the, as it were, the clear statement of the vires, and that's a part of Section 1 which is expressly stated to be without prejudice to the generality of the power. But that's a matter that is apart from the submissions made to you as to legislative design. Again, whatever that means.
The references to reasonable suspicion are in an ancillary context, aren't they? The basic prohibition is on trading with Southern Rhodesia, carrying goods to and from it. You need some enforcement mechanism, and reasonable suspicion entitles you to stop require a master to stop, and if he doesn't, or you think he may not, then enter aboard the ship and or aircraft and so on.
it does go slightly beyond that, my lord. If you look at towards the end of Article 9.1, some 6 lines from the bottom, middle of the line may.
Yes.
In the case of a ship that is reasonably suspected of being or of being about to be used in contravention of Article 7.2, exercise following further powers, which is used for prevention of the commission of such contravention. That is to say, may direct the master to refrain, except with the consent of the authorised officer, from landing at any port specified, any part of the ship's cargo that is so specified, or request the master to take one or more than the steps cause the ship not to proceed with the voyage until the master is notified that he may so proceed, and so on. And so what one sees there, measures that are designed not simply to hold the ring, but are designed substantively to disrupt and prevent trade with Southern Rhodesia, exercisable on the basis of reasonable suspicion.
But that's designed to enable the primary purpose of the order to be effectively applied. And you couldn't insist on too high a standard of suspicion and so on, could you? I mean, you couldn't insist that you could only take these sort of measures against people who were proved to be breaking the sanction. Well, there has to be some kind of stop and search process.
Yes, but my lord, we say that Article 9 in its entirety includes the stop and search, but goes beyond the stop and search. It reflects inevitably the preventative purpose of the particular measure. My lord, what we say in relation to Resolution 1373 is that when one looks at that in its context, one sees a similar strong preventative purpose, and on that basis, there was a clear power within Section 1 of the 1946 Act to make Articles 7 and 8 of the terrorism order operative on the basis of a standard of reasonable suspicion. My lord, before I move directly to that, and just while I have it in my mind, can I mention one very small point? There's been some reference to the sanctions adopted against Zimbabwe, and in particular the government of Zimbabwe. Just for clarity's sake, those were not UN sanctions, but sanctions determined by the European Union. So they have not operated within the context of the United Nations Act within this country. But my lord, turning directly to the question of the use of a standard of reasonable suspicion, the first point we make is that paragraphs 1C and D of Resolution 1373 themselves do not make any express provision as to the standard of proof that is to be required. The language there, the language of commit, is, we suggest, is language which doesn't of itself point directly to any one or other specific standard of proof. But we say that if one looks at the terms of the resolution as a whole, firstly, there is no doubt the Security Council considered international terrorism to pose a grave threat to international peace and security. One gets that directly from the preamble to the resolution, and perhaps most directly from paragraph 5 of the resolution itself, which expressly declares that acts and methods and practices of terrorism are contrary to the purposes and principles of the United Nations. The preventative purpose is, we say, clear if one looks at the resolution as a whole. In your volumes, authorities' volumes, this is volume 19 at tab 162.
Sorry, tab what?
162, my lord.
Are you saying that reasonable suspicion goes simply to burden of proof of the fact that somebody is involved in terrorist activity?
I would say standard of proof, my lord, yes.
Well, in that case, little b in 7.2 is superfluous, isn't it?
Sorry, this is the terrorism order itself, my lord.
Yes.
Well, the function that B provides, well, the function of 7.2
Yes.
is to identify, by reference to the person, the resources which are frozen by 7.1.
Yes.
And so B simply identifies that the resources of a designated person are within the scope of the asset freeze.
Well, it's a person including the designated person. You start off by saying you can freeze the assets of, and then the language precisely reproduces the language of the resolution, which is telling you what to do. And then you add to A, which is reproducing the word in the resolution, B, any designated person. Does that add to the, is that an additional category or a subcategory of A?
No, if one reads B together with the words in brackets in 1, including any designated person, the effect of the words in brackets is simply made to make it clear that the designated person himself cannot deal with his own funds or economic resources. I mean, otherwise, the structure of Article 7 of this order is that the person referred to at the beginning of 7.1 will, apart from the situation where that person is also the designated person, be somebody different from the person whose assets are affected. So person A may not deal with funds or resources belonging to a person referred to in paragraph 2, and the person referred to in paragraph 2 will always be somebody other than person A, unless person A is the designated person.
I could see if B said the designated person, i.e. himself. It doesn't, it says any designated person.
Yes, that would obviously, well, the use of the word any means that designated person A may not deal with the funds of designated person B, but it also means that designated person A may not deal with his own funds. And so, my lord, to that extent, we say it certainly doesn't go any further than anticipated by paragraph 1C of Resolution 1373, which is clearly designed to apply the asset freeze effectively to the person identified by the member state as meeting the criteria. But, my lord, in terms of the adoption within the order of a standard of reasonable suspicion as the basis on which a direction under Article 4 is made, my lord, our points are these. Firstly, we identify and rely on the preventative purpose clear within Resolution 1373. For your note, we place particular reliance on 2 paragraphs in the preamble, which are the 7th and 8th paragraphs, which are about 2/3 of the way down the first page of the resolution, calling on states to work together urgently to prevent and suppress terrorist acts, including through increased cooperation, etc. And then the next preambular paragraph, recognising the need for states to complement international cooperation by taking additional measures, again, to prevent and suppress terrorism. So, again, is looking at it from that perspective. Also, if one looks at the more generally framed parts of the resolution, for example, paragraph 1A of the resolution, again, one sees there that what the resolution is driving at is a system that is preventative. Again, it was not simply, we say, directed towards persons who had already been convicted of actions. It was directed towards preventing those who would engage in terrorism from having or obtaining the financial resources that might enable them to do that. second point that we make is that there is a clear link between the scheme that is required to be established by member states by reason of Resolution 1373 and the further scheme of economic sanctions that stemmed from Resolution 1267 and is now contained in Resolution 1822. That is the series of resolutions which in domestic law have given rise to the Al-Qaeda order. Just as a starting point, in the same bundle, I think you have all the relevant resolutions of the Security Council in relation to each scheme of sanctions. If I could ask you to turn to tab 164, Resolution 1390 is one of the series that is in the 1267 series of resolutions. This resolution itself reaffirmed the particular sanctions measures stemming from Resolution 1267, and one sees that reaffirmation at paragraph 2 of the resolution. If one looks at paragraph 4 of the resolution, one sees there also that in this context, the Security Council is also having regard to the measures it has required under Resolution 1373. Similarly,
I believe I'm right, or at least that Mr. Fordham was right in telling us that all of the UN material is in Part 2 of an appendix. Yeah.
I'm told that he is right, yes.
Yes,
I'm sorry.
yes. Well, that's extremely helpful rather than having to lug different things out.
Yes.
I can't find 1690.
1390.
13.
Is it 1390 you're
Yes,
talking about?
1390.
Yes, it is there, yes.
Would,
1390.
It's just handier, that's all.
yes, I'm sorry.
But don't you worry, carry on.
If we could muddle along together, my notes have been done
There's
by
no
reference to
problem,
tabs.
because I've managed to flag all of these, so I
Excellent,
can find
thank you,
them.
my lady. The next resolution was Resolution 1455, which, for those using the authorities volume, is tab 166. There...
Tab
166.
166, 1455.
Oh, yeah.
In paragraph 14 of that resolution, this is itself dealing primarily with the work of the committee, the 1267 committee, and obligations, the work that committee is to undertake in respect of the scheme of sanctions that stems from Resolution 1267. But one sees that there is also a direct link made between that committee and the reports that are provided by member states under Resolution 1373. Again, the two schemes being seen as part, as it were, of a single preventative effort. And finally, Resolution 1617, which in the authorities bundle, if anyone is still using it, is tab 171. And in that paragraph, firstly, could I ask you to note that when the various previous resolutions are recalled at the beginning of the resolution, there's a reference not simply to the 1267 string of resolutions, but also to 1373 itself. In the seventh preambular paragraph, which is the first paragraph starting on the top of the second page, underscoring the importance of member state designations pursuant to relevant resolutions and robust implementation of existing measures as a significant preventative measure in combating terrorist activity. And operative paragraph 12 on the fourth page of the resolution, again, one sees the link between the 1267 committee and the Counter-Terrorism Committee, which is the committee established in respect of Resolution 1373. Those two committees to work together to identify specific additional steps that states could take to implement the measures outlined in paragraph 1 above. So the second point is that there is this clear link between the two sets of resolutions, and that one draws from that support for the proposition that 1373 is equally preventative in its purpose. The next point, as to the use of the standard of reasonable grounds to suspect, is that is also the standard that has been identified by the Financial Action Task Force, which is an intergovernmental body established by the G7 states. The court has some information about this in the core volume relating to A, K and M's appeals. If you have that available, I'd be grateful if you could find it. Could I ask you to go to page 403 in that volume? You should find there the beginning of a second witness statement of Patrick Guthrie.
Which core volume are we looking at?
So it's the core volume for the A, K and M appeals, my lord.
Yes, and
Well, it's part 1 of appendix. The appendix.
I'm sorry,
I suppose it is part 1.
Core
Yes.
volume on the front.
Well, some of us don't bring our core volumes. We bring the appendices
Yeah.
plus everything else separately.
So
just to confuse you all.
Well, and to add to the confusion, my lady, I received the core volume but not the appendices. So
But
well, it doesn't
appendix
have
1 is in the core volume.
Yes, it doesn't have part 2, I think, is
Yeah.
the tradition.
That's right. It's just to explain why we're having this confusion. But page 408 is what you're looking for.
well, it's wherever the second witness statement of Patrick Guthrie begins. I have it at
That's 403. That's 403.
Yes.
But the actual document is 408.
Yes. Paragraphs 4 to 8 explain what the Financial Action Task Force is and explain that it has issued guidance papers and also interpretive notes as to the approach that should be taken to sanctions, including sanctions under Resolution 1373.
It's Appendix 1.
Can
Can we just get our bearings to be sure we've actually all got it? I'm looking at part 1 of the appendix, and it's page 403.
403, my lord, yes.
And this is Mr. Guthrie's
second statement.
second statement.
And within that, it's paragraph 4 through to and including paragraph 8, where the description occurs.
Thank you.
And when the court has had an opportunity to glance through that, could I ask you to go to page 412, please, which is the beginning of the a document, Freezing of Terrorist Assets, International Best Practices. And within that document, paragraph 5 is at page 415 under the heading Best Practices. And could I ask you to read paragraph 5 itself and then also paragraph 5 Roman 1, please? while you're on that page, Mr. Owen also asked me to draw your attention to paragraph 3 at the top of the page.
3.
3, my lord, yes. And, my lords, my lady, the other part of this document I ask you to note is at page 421, paragraph 6. This is an interpretative note. And paragraph 6 refers specifically to Resolution 1373. Again, if I could invite you to read that paragraph, please.
Which paragraph is it?
Paragraph 6, my lord.
Thank you.
And finally, Mr. Owen asked me to draw your attention to a passage on page 415. It's paragraph 4, and in particular, the second sentence of that paragraph.
Sorry, which page?
It's page 415, my lord, paragraph 4, and in particular, the second sentence. My lords, overall, we say that the commentary and guidance provided by the Financial Action Task Force, again, provides strong support for the submission that the adoption of a reasonable suspicion standard was, firstly, entirely consistent with the requirement arising under Resolution 1373. Again, if that resolution is interpreted and understood on a good faith basis. We also say that the adoption of a standard of reasonable suspicion was entirely within the scope of the power under Section 1 of the 1946 Act. Again, we emphasise within that power the ability to make provision such that the measures identified by the Security Council are effectively applied within the United Kingdom. And so, my lord, in these circumstances, we say that the adoption of the reasonable suspicion standard within the order itself, again, fell squarely within legal action on the part of the executive in accordance with the 1946 Act. Well, I think the only other point I need to deal with in relation to Mr. Owen...
I'm completely unfamiliar with what it is we're looking at in this interpreted note, but it's to do with something, obligations which are being undertaken, which are additional to or complement or something, the obligations under the Security Council resolution? Well, I'm just looking at paragraph 3, scope, beginning, page 420, the thing I'm looking at. Complement the obligation.
Yes.
in paragraph 6 towards the end talks about additionally to ensure and so on. I'm not quite clear what exactly we're...
Well, we say that the passages that we've taken you to on that page and on page 415 are passages which are by way of as it were, explanation of the common understanding amongst the nations that are within the Financial Action Task Force, a large number of nations, as to what the proper interpretation of Resolution 1373 is. Again, an acceptance at an international level that the resolution does pursue a strongly preventative purpose.
What is Special Recommendation 3? It's something additional to, is it?
If one looks at paragraph 1, one sees
two obligations.
Two obligations. The first is compliance with the obligation, with the Security Council resolutions, and the second.
Well, we will find Special Resolution 3 on page 409, will we not?
Madam, I'm not sure if that is the same. It is? Right. I'm told that it is, yes, Madam, my lady, yes, it is.
Well, I would expect it to be.
Yes. It is.
This is all, in fact, an implementation of that, or expansion and clarification.
But there are two parts. One is implementing the United Nations resolution, and then also adopt and implement measures. So, is this not going further than simply dealing with the implementation of the resolutions?
The document as a whole is going further because there are the two obligations, but the parts to which I've taken you to are dealing with the first of those obligations, which is the implementation of 1373. I was going to deal finally in relation to the first part of Mr. Owen's submission with his reliance on the existence of other legislation concerning the terrorist and anti-terrorist field. At the outset, could I make a point as to the meaning and effect of Section 1 of the Act? At times, Mr. Owen's submission proceeded on the basis that there was a requirement under Section 1 for it to be necessary or expedient to make provision by way of order in council rather than by way of some other legislative route. We say that is a misinterpretation of the Act. Necessary or expedient qualifies the content of the order, not which legislative route to provide, rather to pursue. With that first point made, we say simply this. Firstly, that it's entirely unsurprising that there is other legislation and significant quantities of other legislation that covers the general field of anti-terrorism. But it is important to note that there is nothing identified by Mr. Owen in those other legislative provisions that is inconsistent with anything in the terrorism order, or perhaps more properly put the other way round, there is nothing in the terrorism order that is inconsistent with any of the provisions of primary legislation that Mr. Owen has drawn to your attention.
I haven't reminded myself of the terms of the long titles of the legislation, but do they refer to the United Nations, the Security Council resolutions? I don't think they do they? I think it's just general.
I would want to check, but I don't believe that they do, my lord. I'm told they don't.
So they're not purporting actually to be giving effect to that. Well, there's a general purpose, of course, which is explained, but it's not that one.
Indeed, my lord, yes, indeed. As regards the substance of the other legislative provisions that Mr. Owen has identified, it is clear that those measures do not themselves seek to cover the same ground as as paragraphs 1C and 1D of Resolution 1373. They are in some way, shape or form differently formulated. Just by way of example, Mr. Owen referred you to the criminal sanctions in the provisions of the Terrorism Act. Clearly, those sanctions do not directly pursue a strongly preventative purpose, or a specifically preventative purpose. Mr. Owen took you to the Anti-Terrorism, Crime and Security Act 2001 and Schedule 1 of that Act, freezing orders consequent on criminal offences. Again, if one looks, for example, at the definition of cash in respect of those orders, one sees a very limited definition of cash, something that is much narrower than funds or economic resources as identified in Resolution 1373. Similarly, control orders. Now, obviously, those are capable of containing a range of measures, but nevertheless, they are primarily intended to restrict the physical movement of individuals and contact with others. There is no close comparison between control orders and freezing orders. Just by way of one example, under a control order, one could not prohibit third parties making funds available to a controlled person, where clearly that is something that is directly within the intention and purview of paragraphs 1C and D of Resolution 1373. But more importantly than those, as it were, comparative points, our submission comes back to what we say is the most important matter, and is, unfortunately, a rather basic matter for consideration by the court, which is that the question of vires of the order must depend primarily on the language of Section 1 itself. That is both in terms of the substantive provisions in Articles 7 and 8, and including the use of the standard of reasonable suspicion. Again, the fact, for example, that in other legislative contexts different standards are used, is, we say, not to the point. Again, one has to come back to the fundamental question of vires, which itself turns entirely on a proper construction of Section 1 of the 1946 Act. My Lords, those were the submissions we wanted to make in response to Mr. Owen's first ground, the vires ground. I was going to move now, if it's convenient, to the question of legal certainty.
I mean, can you just sort of offer any suggestion as to why it was thought a good idea to do this one, this order under the 1946 Act, but all the rest by legislation?
Well, standing here, I don't have a specific answer to that, but I'll take instructions and provide an answer to you. The only answer I can suggest for myself is, again, to distinguish between the substantive effect of the other legislation that Mr. Owen has identified and the substantive effect and intent of this particular order. Again, they are going to complementary matters, yes, related matters, but not the same matters. But the direct answer to my Lord's question, I'll take instructions. By way of preliminary to our submissions on legal certainty, we make a number of points simply drawing from the Strasbourg case law as to the relevant standard of certainty. The first, the obvious point is that when one is dealing with a law of general application, it is inevitable that those laws will be couched in terms that to a greater or lesser extent are vague. that is simply a function, or a result, I should say, of the legislative process. Secondly, the fact that the application in practice requires an assessment of facts to fall within or outside a particular legislative prohibition does not...
Could you forgive me for just one moment? Because my Lord's question, before you turn to this separate matter,
Yes.
has prompted a question to which I should know the answer but don't. Was there any order in council made to implement 1267? Right afterwards, not...
Right after.
Yeah.
Again, let me check and take instructions on that, my lady, to see what the history of the Al-Qaeda order is.
You can see what I'm getting at.
Yes.
1267 was before 9/11, before, and it's the specific listing of particular people. And if that was dealt with by order in council, one could imagine why, when 1373 comes along, somebody says, well, let's deal with that by order in council too.
Yes.
It's all part of the same process.
No, I can see it's part and parcel of the same question, really, yes.
I'm just putting that to you as a potential answer to my Lord's question.
My lady, I'll take instructions.
To which I'd like to know the answer.
Yes.
Thank you. Sorry to interrupt you.
The second point was that the fact that in order to know whether one falls inside or outside a particular legal provision requires an assessment of facts can't of itself render that provision unenforceable. It's important to have in mind, we say, that the standard is simply that of foreseeability to a reasonable extent of the risks inherent in a course of action. And one sees that repeatedly within the Strasbourg jurisprudence. Two further points. The standard of sufficient foreseeability embraces the possibility that a person is able to assess the likely consequences of their actions by taking appropriate legal advice. It also embraces the possibility in terms of the role of the courts, that is to say, judicial interpretation of statutory provisions. And finally, the requirement of sufficient certainty is not the only safeguard for the individual. And it should not be applied or approached as if it were the only applicable safeguard. There are further principles that apply to protect, for example, the legitimate interests of a person affected by the criminal process, including the principle that the criminal law should not be extensively construed to an accused person's detriment. So foreseeability and certainty itself have their place within a range of principles that are applicable in this area. In relation to the points made by the appellants in the present case, they focus specifically on one aspect of Article 7, that is Article 7.2d, and 2 points within Article 8 of the terrorism order. Generally, we say that Articles 7 and 8 of the order prescribe conduct that is both objectively defined and defined by reference to its effects. This was the point that the Hashman case touched on, the case you referred to this morning, and the distinction drawn in that case between the unacceptable width of the notion of behaviour that was contra bonus mores, on the one hand, but on the other hand, the acceptable prohibition on conduct likely to cause annoyance to others, which was the particular provision in Chohair. The latter was objectively defined and defined by reference to its effects. The former was not. We say that the prohibitions in Article 7 and Article 8 clearly fall on, as it were, the Chohair side of the line, not on the Hashman side of the line. In relation to Article 7.2 directly, the point taken is that the notion of acting on behalf of or acting at the direction of a designated person lacks sufficient certainty. Now, we fully accept that the application of those notions does or will require factual evaluations from case to case. But That of itself is no reason to conclude that they lack sufficient certainty. The notions themselves are tolerably clear, and the existence of difficult cases does not, we say, make good the case that the appellants make, and certainly does not make good the assertion that the terrorism order as a whole is thereby rendered ultra vires. The same general points apply in respect of the appellant's submissions concerning Article 8, and there the targets are particularly the use of the phrase make available within Article 8 and the use of the phrase for the benefit of. Now, in relation to make available, the appellant's submissions, and indeed Mr. Owen's submissions yesterday afternoon, place particular reliance on whether or not lending something falls within the scope of the prohibition. Now, it is important to note the way in which Mr. Owen puts the point. It's not to the extent that it's uncertain on his submission whether or not lending something does fall within Article 8. He is absolutely certain that it does, and relies on that to demonstrate, as he would put it, the disproportionality of Article 8 itself. So even the way Mr. Owen puts it, it's not a certainty point. Dealing with it as he does put it, which is a proportionality point, effectively, we say that in most instances, lending an asset to a designated person is unlikely to fall within the scope of Article 8. And again, the reason for that is that one has to have regard to the definition of economic resources, the notion of convertibility, as it was described by Lord Bingham in the M case, but put in more mundane terms, the definition of economic resources is assets of every kind, which are not funds, but can be used to obtain funds, goods, or services. In the instance of somebody lending an item to somebody else, in most circumstances, that act is not going to be an act that provides that person with economic resources, because the fund, what is lent, will not itself be convertible, other than by an act that would be not permitted under the terms of the lending.
So the correspondence was simply erroneous when it
Yes.
suggested that cars on loan would be.
Yes. I mean, clearly there will be difficult cases on, potentially there are difficult cases on the facts. My Lord Mance made the point yesterday afternoon that it's very unlikely that one could use a private car that had been lent to you, for example, running a taxi service, because it wouldn't be licensed, and Lord Mance made the point that the insurance would probably be invalidated. Now, in those circumstances, one can see that is not an act that is likely to fall within Article 8 of the order. There may be different circumstances that require a different analysis, but on the run-of-the-mill, we would say that lending does not fall within Article 8. There may be difficult cases, but that neither renders the provision disproportionate, nor does it render it uncertain.
You're not going to give any ground on M. What's the status of M at the moment in the ECJ?
Yes, I am coming to M. My Lord, M has been listed for a hearing on the 11th of November. It was delayed initially following the reference in the wake of the decision of the court in Cardi, because the Commission the Council wanted some time to consider what steps it was going to take in respect of Regulation 881 following the decision of the court in Cardi. But as I say, a hearing was notified, I think, last week, and the hearing is to be on the 11th of November. But on, as it were, the substantive issue in M, my Lord, it comes in two ways. It comes in proportionality, and I'll deal with that in a moment. But in relation to certainty, the point is very much as was suggested yesterday afternoon. In M, there is what is said to be a wide application of for the benefit of, which includes the payment of state benefits to a household that includes a designated person. It is said that those payments are, because of the nature of state benefits, for the benefit of the designated person. And there is a narrow construction that says that it's not. Now, one of those constructions will be right, The resolution of that point does not identify Regulation 8 as being uncertain. It's simply a matter of judicial interpretation, and judicial interpretation is routinely anticipated by the Strasbourg Court as being part and parcel of the process of the life of legislation of general effect. Before moving to proportionality, could I say something about licences? Mr. Owen attacks the licences on the basis that they represent an unacceptably wide discretion to the Treasury. Several points to make. The first is that there is no challenge in these proceedings to any licence made by the Treasury. The preliminary issues identified by the appellants simply relate to Article 7 and Article 8 of the Terrorism Order. There is no challenge to any licence. So to that extent, if Mr. Owen has a complaint about a licence, this is not the case that he's going to raise it in. The second point is that, with respect, Mr. Owen misunderstands the purpose of a licence. The licence is not by way of... One has to look at the provisions of the order as a whole, what the order anticipates. And so the licence provisions are not by way of further interference, they are by way effectively of derogation to the effect that Article 7 and Article 8 of the Terrorism Order would otherwise have.
Am I right in thinking that the power to grant licences is not actually limited by the terms of 1452?
That is correct. One looks in
It's just a general power to grant licences.
The practice of the Treasury is to exercise that power in accordance with
But they could, in fact, grant wholesale dispensations.
theoretically, my lady, yes, but if they did, one can see that would be inconsistent with the purpose of the order, which is to give effect to the
Yes. No, I appreciate that, but given there are problems of interpretation of certain bits of it, it would be open to the Treasury to say, we are going to deal with that sort of thing in this way. For example, to take the line that these are subsistence benefits, and whatever the view of for the benefit of, we're going to accept that this is all right, so that they didn't have to intrude upon the lives of the wives and children. You do understand I'm more interested in the lives of the wives and children than I am in the lives of the other people involved.
which effectively interpreted for the benefit of in the narrow sense contended for in M, while at the same time the Treasury's view was that for the benefit of should be interpreted in the broader sense that it contends. One can see that there have been elements of schizophrenia about the way in which the Treasury will be approaching these matters. And so, however, I appreciate the point my lady makes, that one needs to look at the regulations as a whole, and there are different aspects of the regulations that work complementary to each other to create an overall effect. And I not only appreciate that point, I would rely on that point. But clearly one would anticipate and expect the Treasury to take a consistent approach as regards the operation of the different parts of the order. Clearly, in relation...
We wouldn't be complying with our obligations and satisfying the monitoring committee, would we, if we started giving... if the Treasury started giving licences which were way outside 1452.
That would be a situation slightly different from the situation envisaged by my Lady Hell, but yes, indeed, that would undoubtedly be the case. Yes.
My situation is where the overall scope of the restrictions is perhaps going beyond what is required by 1373 or, for that matter.
But I would suggest that in that situation, if it's a question of interpretation and construction, it should be dealt with as a question of interpretation and construction rather than by way of as it were, a backdoor licensing power. In relation to the licenses themselves, to the extent that there is any issue as to the certainty of the terms of a license, that is a matter that goes to the legality of the exercise of a power under Article 11. It's not a matter that goes to the vires to make the terrorism order itself in terms of certainty. And we say that that's an important point to have in mind, particularly in relation, as it were, to the day-to-day impact of the terrorism order on those who are subject to its provisions. These issues do come before you as preliminary issues. On that basis, you are entitled to approach the terrorism order on the basis that it works as anticipated, as reasonably anticipated, that there are the restrictions within Article 7 and Article 8, but they are mitigated and ameliorated to the extent of basic expenses and extraordinary expenses by licenses and a licence system that works effectively under Article 11 of the order itself. I'm turning now to the question of proportionality, but before I do that, could I just go back to a part of Mr. Owen's submissions yesterday? Part of his submission was as it were, a trot through. I don't mean to disparage what he said, but a trot through various legislative provisions. And at the end of that, he took you to the 2001 terrorism order, the 06 version, and then the 09 version. And could I just make a few observations in relation to that part of the of his submissions? In relation to the 2001 order, which for your note is volume 18, tab 152, Mr. Owen made the point as to the absence of a reference to economic resources. We say, yes, that's correct, but important to note, an extensive definition of funds, which includes the notion of economic benefits of any kind. There was some discussion from the bench yesterday afternoon as to the example of a diamond ring. And can I just make it clear that under the 2001 order, one would not have been able to give a diamond ring to a person falling within the scope, and that would be the effect of Article 3 of that order, which would be making funds available. And if one applies that with the extended definition of funds, one can see that it wouldn't be a question that you could give him the ring but he couldn't use it, you couldn't give him the ring at all. Also important to note that both Article 3 and Article 4 of that order would operate subject to the provisions of any licence made under Article 12 of the order. It is correct to point out that the notion of a designated person did not exist within the 2001 order. That was a notion that was introduced as part of the modifications introduced by the 2006 order. Again, the further modifications that have been made in the 2009 version of the order link the operation, for example, of the prohibition on the use of funds to those funds which belong to the designated person or somebody owned or controlled by the designated person. This is within the specific definition of restricted person within the 2009 order. Perhaps I can just show you how that works in the 2009 order. If I could ask you to look at the 2006 order first, just to see where Article 7 was. That is in volume 18 of the authorities at tab 154, if that's the most convenient place for you. My Lord Phillips was looking at this provision earlier. Article 7, 3 pages in, 4 pages into this, prevents a person dealing with the funds or economic resources owned or held by anyone within a further 4 categories of person, those persons categorised in Article 7, sub 2. It includes a designated person, a person owned or controlled by a person in A or B, or a person acting on behalf of A or B. And in addition to a designated person, it also includes, at 7A, any person who commits, attempts to commit, participates in or facilitates the commission of acts of terrorism. If one looks at the 2009 order, one sees that there has been a modification of the operation of Article 7. Articles 7 and 8 themselves are now split between Articles 11 to 14 of the 2009 order. The 2009 order is at tab 155.
Tab what?
155, my lord.
And it's split between which numbers?
11 to 14. If you have Articles 11 to 14 open in front of you, 11 and 12 refer to making funds or financial services available, 11 available to a restricted person, 12 for the benefit of a restricted person. So that was previously the ground that was covered in part by Article 8 of the 2006 order. And then 13 and 14 deal with making economic resources available, 13 again to a restricted person, and 14 for the benefit of a restricted person. But if I could ask you to look at the definition of restricted person, which is at Article 2 of the order on the fourth page, page 4, and compare that with the previous provisions of Article 7.2 of the 2006 order, one sees that restricted person now comprises only three categories: the designated person, the person owned or controlled, or the person acting on behalf. And what has fallen out was the category that was previously at Article 7.2a. Not a provision that's material to these appeals, but I draw your attention to this. Generally, one sees a process of refinement and modification in the successive iterations of the order. Now, in his printed case, Mr. Owen relies on these changes to suggest that the 2006 order is disproportionate, and Articles 7 and 8 of that order are disproportionate, and the order itself is on that basis, is unlawful. We say that no such conclusion should be drawn. One sees in the history of these three orders a process, as we say, of development, of refinement. That is a process that, simply as a matter of legislative good practice, is to be encouraged, rather than to be discouraged by the suggestion that if one, in version 3, restricts in some way a provision that existed within version 2, that automatically proves that version 2 was unlawful. Version 2, in this case the 2006 order, we say needs to be considered on its own terms. And on those terms, we say that Articles 7 and 8 are proportionate provisions. And coming directly to the question of proportionality, I think it's a fair assessment of Mr. Owen's submissions to say that they are directed primarily to the effect on third parties, specifically the effect on family life in a situation where a designated person forms part of a household and that household is supported entirely by state benefits. That is the situation from which Mr. Owen draws all, if not certainly most, I'd say, if not all of his examples. Clearly, the first point to note is that the existence of that situation is premised on a particular application of the phrase "for the benefit of." And I don't shy away from the argument that "for the benefit of" is broad enough to encompass a payment made by a benefits agency in support of a family that includes a designated person. That is the question of construction that, in the context of Regulation 881, will be determined by the European Court. But we do submit that, simply as a matter of ordinary construction of Regulation 8 of the terrorism order, that situation does fall within the notion of making funds available for the benefit of. Now, that argument, right or wrong,
we're going to have a very brief German now, then we'll continue to
thank you.
Would it be possible for them to tweak the sound to make it a bit louder? Trouble hearing. Thank you. Fine. All rise.
My Lords, turning to the question of proportionality and the impact of the terrorism order on third parties, including family members, could I first make what perhaps is an obvious point, that some impact on third parties is an inevitable consequence of any scheme of sanctions. That is even the case in relation to targeted economic sanctions, such as those which are put in place by the terrorism order itself. As to the general approach in terms of proportionality, could I ask you to go to the judgment of the European Court of Justice in the Bosphorus case, which is volume 13, tab 103. And behind that tab, you have first the judgment of the court itself, which is 6 pages, and then behind that, you have the opinion of the Advocate General Jacobs, in that particular case. Could I ask you to look at the Advocate General's opinion first, please? And just by way of context, first at paragraph 20, this is just read it to get the facts of the case. If I could ask you to read paragraph 20, paragraphs 22 to 23, and then paragraph 27, please. That should give you an idea of the circumstances.
There's a sanctions busting.
Yes, yes. You see the particular measure back at paragraph 14. It's Article 8 as the particular measure in question.
103 of 113.
And then for how that actually applied to Bosphorus, probably best seen from paragraphs 31 and 32 of Advocate General Jacobs' opinion. I'm not sure one would necessarily describe it as sanctions busting, but certainly it was action in breach of sanctions.
Yeah.
And the next point in the judgment is paragraphs 51 to 53, on page numbers at the bottom 3971. But also just to make a point that was again repeated by the court itself in Cardi, as to paragraph 51, it is well established that the respect for fundamental rights forms part of the general principles of community law. At paragraph 52, there's a reference to Article F2 of the Treaty on the European Union. And then at the end of that paragraph, in relation to the EC Treaty, it confirms and consolidates the court's case law, underlining paramount importance of respect for fundamental rights. And then at 53, respect for fundamental rights is thus a condition of the lawfulness of community acts. And then the Advocate General's reasoning is from paragraph 57. And his reasoning is based largely on the jurisprudence of the Strasbourg Court in relation to Article 1 of Protocol 1. At paragraph 57, he identifies the principles identified as being contained within Article 1 of Protocol 1. Paragraph 59, he refers to an earlier decision of the Strasbourg Court, Agosi and United Kingdom, where a fair balance test had been applied to the issue of whether confiscation was justified as a measure of enforcement against an innocent owner. And then at paragraph 62, 6 lines from the end of the paragraph towards the right-hand margin, the sentence starts, "Indeed, the essential question." Indeed, the essential question is whether the obvious interference with Bosphorus Airways' possession of the aircraft is a proportionate measure in light of the aims of general interest which the regulation seeks to achieve. And at 64, he says, on the other hand, it is also obvious that there is a particularly strong public interest in enforcing embargo measures decided by the United Nations Security Council. Indeed, it is difficult to think of any stronger type of public interest than that of stopping a civil war as devastating as the one which engulfed the former Yugoslavia. The international community took the view that in order to stop that war, it was necessary to put pressure on the Federal Republic of Yugoslavia. And 2 lines further down, accordingly, the Security Council decided to adopt and subsequently strengthen economic sanctions which were implemented by the community. Unavoidably, such sanctions affect property rights, including those of innocent economic operators. And then at the end of the paragraph, the last sentence, such losses are inevitable if the sanctions are to be effective. That does not, of course, mean that in such circumstance any type of interference with the right to property should be tolerated. If it were demonstrated that such interference was wholly unreasonable in the light of the aims which the competent authorities sought to achieve, then it would be necessary for this court to intervene. He then considered the particular measures, and the conclusion at 65 was thus the sanctions measures do, in my view, justify the contested decisions. And then at 66, Bosphorus Airways has emphasised what it considers the drastic financial and commercial effects of the decision. I am not convinced those effects can be given the weight Bosphorus suggests. The financial consequences may vary. In other situations, a lessee might simply be able to cancel the agreement and lease another aircraft. In any case, I do not think it is possible to set aside a general measure of this kind simply because of the financial consequences which it may have in a particular case. The relevant question seems to me to be whether the impounding of an aircraft is in accordance with the measure in circumstances where the owner, but not the lessee, is an undertaking from the territory against which the sanctions are directed. But even if it were relevant to take account of the losses allegedly incurred by Bosphorus Airways, I do not think the principle of proportionality would be infringed in view of the importance of the public interest involved. As to the judgment of the court, which is at the beginning of the tab, the relevant passage is from paragraph 19, and in particular, could I ask you to read paragraphs 20 to 23 and also paragraph 26. We also say it's important to note that precisely the same reasoning was repeated by the European Court in Cardi. Just for your note at the moment, Cardi is volume 13, tab 105, and the relevant paragraph is paragraph 363. But in terms of the acceptance...
Paragraph word.
363, my lord. In the present case, as regards the specific question of proportionality by reference to interference with the interests of third parties, we make several general points. Firstly, the point arising from Bosphorus is that, in principle, an impact on third parties is not of itself sufficient to render disproportionate a system of targeted economic sanctions, that one has to weigh in the balance the important public interest being pursued by the sanction scheme itself. Applied to the present case, clearly there is an important public interest. That interest itself is encapsulated within the Security Council resolution itself, and the decision of the Security Council that the adoption of that measure was itself something that was necessary in order to maintain international peace and security. Secondly, and coming to the terms of the order, we say you have to take into account not simply Articles 7 and 8, but also Article 11. And so the scheme established under the order is not simply one that, by reason of Article 7 and Article 8, would freeze all assets and prevent any replacement assets being made available. It is also one, through Article 11, which specifically anticipates exceptions being made to the extent necessary to meet basic expenses and extraordinary expenses. And in the present case, it is the position that licences were made in respect of each of the appellants. And those licences did permit the payment of the state benefits to which the family units were entitled. Those benefits were all available and remain available for use in relation to meeting the basic expenses of the household. If you need an example of one of the basic expenses licences, one finds it in the appendix. And an example is at page 234 to 235. This is the licence that was issued in October 2007 in relation to A. And you see the structure of the licence. The benefits payments were to be paid into what was referred to as the new account, an account held by a spouse. Those funds could be applied to meet the basic expenses of the household, including the basic expenses of the designated person. There was a reporting requirement at paragraph or clause 11 of the licence, and one sees that there was a requirement on a monthly basis to provide details of how amounts paid out of the new account were applied, and where possible, receipts should be provided. Now, some form of reporting requirement is, we say, inevitable if the system of allowances for basic expenses is to be properly operated. It is certainly legitimate if payments in respect of basic expenses are being made, for the Treasury to take some steps, some basic steps, to identify whether the funds have been used to meet basic expenses or whether they have been used for some other purpose.
But only enough to cover the basic expenses. How are they going to live if they don't spend them on?
But my Lord, not making a point as to the level of the payment at the moment. The level of the payment is in practice the level of the state benefits. But the point I'm making is that the Treasury is entitled, in proper operation of the sanctions scheme, to ask for some indication that the monies that have been provided were in fact spent on basic expenses rather than on for example, on matters that would fall within the scope of what is prohibited by.
Without prejudice to the meaning of for the benefit of in the EU regulation,
yes,
and in this, is there any power in the Treasury to stop the wife spending the money which is intended as benefits for her and the children on anything for her and the children?
But I'm not sure I can answer that question on a basis of without prejudice to the argument in M, because I would suggest that the answer to the question does depend on the answer to the question in M. The interpretation applied by...
So a birthday present for the disabled child is for the benefit of the designated person,
No, that's not what I'm saying, my lady.
Well, that's what I'm asking you. What I'm asking you is, this is the wife who's... And I can understand that on the wider definition of for the benefit of, benefits that are payable to the wife, but which may be used in part for basic subsistence of the husband, make that assumption. Is there any power to stop the wife making those payments available to the benefit of her children and herself, even if that goes beyond basic expenses? In other words, buying an expensive Christmas present, saving up to buy an expensive Christmas present for one of these families has a disabled child, I know.
Melody, I have to give you my answer to that question by taking a step back first, if I may.
I just want yes or no.
Well,
that's all I want. Then I'll work out what your reasoning may be.
If I could have... Well, I'll take the opportunity, if I may, to explain what my reasoning is. This is the question that arises directly in M and the Treasury in relation to Regulation 881. This is that question. The point that is behind the Treasury's construction of for the benefit of in that case, and which I think addresses the point you raised now, is that what is in question is whether or not the benefits agency can make the payment of benefits to the family. Is that payment a payment for the benefit of the designated person? If one answers that question yes, as the Treasury does in that case, it is a payment that needs to be authorised by a licence if it is to be made. Otherwise, it cannot be made consistent with Regulation 8. The licence itself, as you have seen, permits that payment by the benefits agency to be spent in relation to basic expenses. And so the answer to my lady's question is that all of the money so paid in that scenario is subject to the requirement that it should be spent on basic expenses. Now, what basic expenses are is a matter that has been generally defined and is a matter on which specific guidance can be sought from the Treasury if people wish to seek guidance from the Treasury, or ultimately can be determined by the courts. But the reason that the basic expenses requirement attaches to the example that you give on the Treasury's construction for the benefit of is that what is bitten, as it were, what is caught by Article 8 is the payment to the household. It's not a question of the transactions that follow, it's a question of the initial payment of benefits being a payment which is for the benefit of that household, or rather for the benefit of the designated person, because of the purpose of the benefit payment, which is to support the household as a whole. That's the basis on which, generally speaking, those benefits are calculated. Now,
actually, I didn't get an answer to that question either in the M case, as to how the benefits were calculated, which I did ask. But I come back to my basic question. I can quite understand that one might take a view that says that for the benefit of covered payments that were a global whole that was partly for the benefit of the designated person and partly for the benefit of other people. And I could understand that then the result might be that you were entitled to monitor whether those payments had been used for the benefit of the designated person, in which case that could be limited to basic expenses. But I'm still struggling with what the basis is for preventing other people spending money which is theirs for whatever purposes they want to spend it.
Majesty, I can make one further point that I hope helps, but otherwise the answer isn't going to improve on the answer I've given you. The starting point is whether or not the payment by the benefits agency to the family is properly identified as a payment for the benefit of the designated person. If one answers that question no, the answer to my lady's question as to the expensive gift for the child, brought by the mother for the child, would be no, that is not caught by Regulation 8. But that would simply be because you had answered the initial question as to the nature of the payment from the benefits agent to the family in the negative. If you answer,
we're going round in circles because we're making the same point time and again.
I know, but Molly, there is one further point as to the question of basic expenses and why is it that basic expenses can include the basic expenses of somebody who is not a designated person. If one looks at, has as a starting point, Resolution 1452, which is in volume 19 of the authorities' volumes. At tab 165. It's probably also in the appendix as well somewhere. I'm sorry not to have the reference. This is the starting point for the exception for basic expenses, for legal expenses and for extraordinary expenses. There is no restriction within Resolution 1452 to these being the basic expenses of the designated person. If one considers the situation as a whole, there is a very obvious reason for that. As the Bosphorus case demonstrates, there will be situations where third parties are adversely affected by the operation of the sanctions scheme. If the exception for basic expenses only related to the basic expenses of the designated person, one would see there would be no means of alleviating the position of the third party, when in fact it might well be that it was the position of the third party that you would most want to ameliorate. And so the question of basic expenses is not limited to the basic expenses of the designated person. Hence, when one considers the specific example of a family subsisting on state benefits, if one answers the initial question, is that payment of state benefits a payment for the benefit of the designated person? If one answers that question, yes, the exception in relation to basic expenses, consistent with Resolution 1452, should be applied equally to the basic expenses of the designated person and to the basic expenses of any third party who is adversely affected by the resolution. If one took the Bosphorus example and assumed that there was something like Resolution 1452 within the scheme of sanctions directed at the Republic of Yugoslavia, Bosphorus would have been someone in the position to benefit, potentially, from the exception along the lines of 1452. If it said that the effect of these sanctions on me, grounding my aircraft so I can't run my business, is such that I am affected in a way that Resolution 1452 says I should not be affected, well then there should be relief for me from those sanctions, even though I am a third party. Precisely the same principle applies, well, actually, the principle that does apply is within 1452 and hence applies to the family unit. So if one answers the initial question, yes, hence the conclusion that the basic expenses include the basic expenses of the wife and the children, as well as the basic expense of the designated person. So one sees, again, in terms of the overall working of the machine, if one wants to put it in those terms, the Treasury's approach to the meaning of for the benefit of is a wider approach, but it also takes a wider approach to the meaning of basic expenses in relation to 1452 in terms of whose basic expenses count. And so one sees that there are balances within the interpretation of the scheme. But returning to the question of proportionality, yes, we accept that there will be adverse impacts on third parties. But we say that having regard to the important, undeniably important public purpose being pursued by the scheme, the existence of the licensing system under Article 11, and the reality that one will never, in practice, be able to apply effectively a system of sanctions and at the same time hold harmless all third parties. Nevertheless, the provisions of the terrorism order as a whole are proportionate provisions, even though they impact upon third parties.
Can I just understand one point about the proportionality argument? Why isn't the primary argument, consistently with other parts of your case, that in fact this, insofar as this order gives effect to the Security Council resolution, that's the end of the matter. No question of proportionality arises. And
no question strictly of human rights arising.
Yes.
Yes. My Lord, the answer to that question lies in the judgment of the House of Lords in Al Jeddah.
In what?
In Al Jeddah.
Al Jeddah, sorry, yes, I see.
This depends on the operation of Article 103 of the UN Charter at the international level. And the point made by various members of the House of Lords in Al Jeddah was that although Article 103 had this effect of displacing obligations under other international instruments, including the Convention of Human Rights, it only did so to the extent necessary, rendered necessary by the resolution itself. Now, in the context of 1267 and the resolutions that follow, which are the basis of the Al-Qaeda order, one has a situation where the Security Council has specifically identified people and specifically identified measures that should be taken against those people, and obliged the states, in terms of their charter obligations, to apply those measures. And so in those circumstances, we say that the Al Jeddah principle directly applies, and there is no possibility of relying on the Human Rights Act in order to challenge the effect of the Al-Qaeda order, because, as a matter of international law, the claim under the Human Rights Convention would not be available before the Strasbourg Court. In relation to 1373, the position is different. The Security Council resolution identifies criteria that member states are to apply, but then leaves to the member states the responsibility for the application of those criteria. And on that basis, the argument that was available in Al Jeddah, and I would say is available in relation to the Al-Qaeda order, is not available in respect to the terrorism order. So the short answer, my Lord, is that the difference in approach stems from the different nature of the two Security Council resolutions.
The argument is available in relation to some of the points which you deal with under the head of proportionality, such as the words directly or indirectly, because they are actually in the Security Council resolution.
Yes, and my Lord, the way we put the point in relation to those matters is not to say that the effect of the resolution is simply to bar out any question of Human Rights Act testing, but we say that the fact that this stems from a Security Council resolution provides very strong weight in favour of the conclusion that domestic provisions in the same terms are proportionate domestic.
Well, that's what I didn't quite understand. Why is it part of a balancing exercise rather than, insofar as precisely the same wording is used, rather than the conclusive element? I mean, if you're using precisely the words which the UN requires, then that would seem, on your argument, to be the end of the matter, full stop.
Well, my Lord, it may be thought to be an unduly cautious approach on the part of the Treasury, but they were alive to the need to apply the principle in Al Jeddah properly and not to seek, as it were, to extend that principle. And so that they were conscious of the fact, and remain conscious of the fact, that, well, to the extent that there is a clear and governing decision of the Security Council along the lines of the decisions that are made under Resolution 1822, the 1267 regime, in those circumstances, the Al-Jeddah argument ran, but in other circumstances, caution was preferable. And in those circumstances, it should be accepted that in principle there was a Human Rights Act challenge available, but that in practice the answer to that challenge ought to depend heavily on the fact that these are measures that directly mirror Security Council decisions. My Lords and my Lady, just one more point to make. I was asked two questions, one by my Lord Simon Brown and one by my Lady Baroness Hale. I can answer your question, my Lady, to some extent. You asked whether or not there had been an order that implemented 1267. Yeah. There was such an order. We don't have copies of it. It's referred to in one of the appendices, but I can give you the reference to it. It was it's the Afghanistan United Nations Measures Order 1999. And, my Lord, I'll attempt to get instructions overnight to provide a sensible answer to your question.
Thank you.
I think my question was really, if there was such an order,
yes,
was it implementing a similar sort of regime? Is that the reason why it was chosen to continue yes, doing this sort of regime under that yes, scheme rather than the other, which perhaps you can get instructions
my Lady,
on?
So on my feet, I can see the sense of that, but I will yes, take instructions. My Lord, unless I can assist the Court further, those are my submissions in response to Mr Owen's appeal.
My learned friend began with saying that there is a parallel to be drawn between Section 2 of the European Communities Act 1972 and the UN Act 1946, and he took you to Oakley. In our submission, that is something of an own goal in the context of the UN Act. Oakley refers to the European Communities Act 1972 as being sui generis, and for good reason, for the reasons that I gave in my opening submissions by reference to factor tame. In Jackson, the House of Lords considered other examples of legal orders which had been created, if you like, to qualify the Dycean concept of parliamentary sovereignty, and my Lord Hope referred to the Acts of Union 1707, and Baroness Hale and Lord Steyne referred to the 1972 European Communities Act, the Human Rights Act, as examples of qualifications to the orthodox theory of parliamentary sovereignty. And frankly, nobody to date has taken the view, until Mr Swift has developed the argument before you, that Section 1 of the UN Act is to be compared to, in terms of its status and the settled understanding that Parliament had when it enacted that particular instrument. No one has suggested that there's any comparison between those two legal orders. And if he's right about that, it does amount to the kind of peaceful revolution that my Lord Roger referred to in national life, having taken place in 1946, and frankly not been understood until today. And we submit, in all the circumstances, it's really a point against my learned friend that he has to draw on an analogy or seek to make a parallel with Section 2. The consequence of that, and it really is all of a piece of his submissions, is that Section 1 of the UN Act was a blank cheque form of legislation. It was conferring on the executive an uncontrolled power to make law depending on future decisions and formulations of an international body in the form of the United Nations. And he says that there is a clear purpose behind the UN Act, which was, in effect, in all circumstances and forever, to enable the United Kingdom, or the executive, to formulate law so as to ensure compliance with Security Council resolutions. My Lord Brown asked the straightforward question to my learned friend, what about control orders? And Mr Swift was reluctant initially to answer that question, but in the end, I think, accepted that the logic of his argument is that, yes, control orders could be enacted via the procedure under the Order in Council. And he said the only qualification to that, or rather the only safeguard in relation to that decision-making, would be a political one in the way that Lady Baroness Hale pointed out. In my submission, he had to make that submission because the logic of the argument must be that the terms of Section 1, unqualified in any way, as he says it is, in terms of the duty or the discretion, the power to give force to Security Council resolutions, would embrace all forms of anti-terrorist legislation. Because if one looks simply at paragraph 1A, prevent and suppress the financing of terrorist acts, and 2B, take necessary steps to prevent the commission of terrorist acts, that would clearly, on his analysis, be competent to cover the enactment of control orders. He criticised the formulation, the limiting formula that we drafted on the basis that it found no reflection in the language of the Act. And of course, the answer to that is no, of course it does not. It's a distillation of principle based on what we submit are, in fact, two quite separate principles. The principle of legality. I suggested that the other presumption against blank cheque legislation was implicit in the principle of legality, and I don't shy away from that, but it actually is a separate freestanding principle we submit. And my learned friend didn't address that at all, and he didn't address the way in which in the two New Zealand authorities the judges formulated that principle in the context of very wide delegation powers. And in our submission, my learned friend's reference to the always speaking concept, both in relation to Article 41 and Section 1, is in effect saying this is a form of blank cheque legislation, conferring on the executive the ability to make law at will, dependent on Security Council resolutions.
So you say it's not always speaking.
It's a different point. One goes back to what Parliament intended in 1946. I think we accept that's an issue of construction. It's always speaking on the basis of the limitations that we say are inherent in it, but they're always subject to those limitations.
It's got, I mean, it applies to the, you don't say it applies to the world of UN resolutions as they develop and the world changes and...
Subject to the limitation. If we are right, and Mr. Fordham's submissions are correct, about the approach to the language of a clause such as Section 1, Mr. Fordham emphasised, by reference to other cases on the principle of legality, not just Pearson and Sims, that is precisely this type of language that attracts the principle of legality. And if we are right, there is a linked principle which presumes, in the absence of the most clear, crystal clear language, that Parliament has genuinely sought to delegate its powers to the executive on an uncontrolled basis because it depends on decisions of an external body.
You could apply this sort of argument under the European Communities Act. I'm not sure whether the Act's been amended to refer to all the subsequent treaties, but it probably has. But leave aside that, the European Court of Justice has discovered some interesting competence under the first chapter in relation to the creation of criminal offences by qualified majority voting in environmental and pollution matters, which no one, I think, would have conceived at the time of any relevant treaty. I just want to say that's outside the scope of the Act because nobody ever dreamt of it.
But that's because if one begins at the starting point with what Section 2.2 of the European Communities Act intended, one starts in a very different place than you start with Section 1.
Well, that was a blank cheque.
Well, it was in effect to succeed sovereignty to the European community, subject to arguments before the ECJ about human rights arguments and so on, and convention arguments. But in terms of an acceptance that one was entering into an organisation which was a lawmaking body with a concept of direct effect, it was qualitatively different, we submit, from the UN.
Why is the revolution brought about in 1945 by the creation of the United Nations less dramatic, less important than the revolution brought about by entering the common market.
Because we did not, and it certainly was not understood that we were entering a legislative body. We were in effect ceding lawmaking powers to an external body. And that's the difference. My own friend's point about the United Nations structure is it is not a legislative body. He says it enters, the Security Council has negotiations and discussions, but it does not produce law. And my Lord Walker put the question back, well, does that not make it quite clear that ultimately then Section 1 is a transposition power? But the question is, what are the limits on the power of transposition?
Is it really this? That you're saying that, one could say that the Charter is always speaking, and therefore the scope of the powers given to the Security Council can expand according to the needs of maintaining order and peace and so on around the world.
Yes.
But the relationship between Parliament and the Executive
Yes.
is something for our Constitution. And there is nothing in the Charter that justifies the idea that there is a sort of ever-expanding
Yes.
competence to the Executive to the detriment of the parliamentary process.
Yes.
And that, if I understand your position,
Yes,
is
that
something which one would want to understand in 1946.
Yeah.
There was a cessation or a ceding, as it were, of power to the Executive to the extent described.
Yes.
But it wasn't, you say, to be taken to be capable of being expanded just because
Yes.
the Security Council was beginning to expand its competence
Yes.
or the way in which it went about its affairs.
My Lord, yes.
I put it rather loosely, but I think that's
that
the
is
point
the
you're
argument.
making.
And that does not conflict with the domestic law concept of a statute always speaking, because within the limitation that we have sought to formulate about the need for specific measures to be formulated in relation to identified states, entities, and targets, and so on, then, of course, that accepts the idea that the measures that are formulated within those parameters will change with time.
It isn't. I mean, it isn't always speaking in the sense that you say the kinds of Security Council resolution to which Section 1 applies are frozen in time as by the understanding which there would have been in 1946.
We say to the extent that the phrase "frozen in time" is being applied, it is focusing on what Parliament intended the Executive to be able to do.
Yes, I understand. And that means you say it only applies to resolutions of the kind
Yes,
which would have been, if you'd asked somebody at the time in 1945, 46, that's the kind of thing which will be covered by
Yes.
Security Council
Yes.
resolutions. And if subsequently people have come up with slightly different ideas for Security Council resolutions, that doesn't.
Yeah, and again, it's not a pepper and heart point, but Parliament was told, one of the members raised the question of whether we ought to be having a proper debate about the whole UN structure. And that member said, no, we can do that another day. Here we're just doing the limited work of ensuring that we can be the first country in the world to show that we can impose this duty on our citizens. And that was, it's relevant to the settled understanding of what Parliament was doing at the time, what it thought it was doing. And it was said that Article 41 is the only provision of the Charter that, in the view of the government, required primary legislation, and here it was being given quickly to enable us to be in that position. Now, we say that just looking at that language and the historical context and the previous history of sanctions between states and so on raises questions about how the enactment of this clause could be said to be anything like what Parliament did in Section 2 in the context of a wide-ranging debate with a referendum and so on, and an understanding of what the Treaty of Rome's obligations were and the lawmaking powers of the community institutions. The truth is that in answering my Lord Brown's question, uncomfortably as it may have appeared he has not come up with any limiting principle. He's criticised our limiting principle, but has not offered anything in the alternative, although he was content, it would seem, to be drawn into a discussion of specifics versus generalities. And he'd said, for example, that Article 2b, take the necessary steps to prevent the commission of terrorist acts, was one of those examples which exists at too high a level of generality, arguably, to be the basis for an ordering council. And says, he said at one point, if one is in this grey area, the arguments would be more intense. Well, with great respect, we are plainly in a grey area in this particular kind of Security Council resolution. Sir Michael Wood tells us we are in his lecture. He flags up 1373 as a quite new and different departure from the Security Council. There may be questions about the vires of it, and there are arguments about it amongst international lawyers. That's neither here nor there. But the suggestion that this falls into something which is not a grey area, something which is appropriate and competent for this kind of Section 1.1 transposition is, we submit, quite unsustainable. And my learned friend's reluctance and discomfort in having to deal with the control order question and having to say ultimately that's a matter for the politicians, it is not a matter for legality, is, we submit, not a satisfactory answer. And we do submit that the principle, the presumption against blank check legislation, which is reflected in the two New Zealand cases, and it may be thought to be surprising this issue hasn't come up before, but it may be that precisely this type of provision is very unusual, indeed unique, in the extent to which, if Mr. Swift is right, Parliament has, apparently without realising it, given away its legislative powers dependent on the decisions of an international body in such a way that if the executive chose to put all our anti-terrorism legislation on the statute book through ordering council, the only protection would be the political one. And in fact, there would be nothing that the courts, there's no appropriate role, I think was the way he described it, for the courts to question the legislative choice. In relation to the question of vires, my Lord Brand put to Mr. Swift, well, what about Wednesbury? Are there any circumstances in which one could attack the minister's decision under the Section 1 order as opposed to attacking it via a virus challenge? And it's true, we have not formulated our argument as an irrationality one, although I do respectfully adopt Mr. Fordham's point that the words necessary or expedient do go both to mode and content. But the reason a Wednesbury challenge would be difficult is one only gets to that point if one has failed in the virus argument. In other words, it's accepted that the power in Section 1 is unqualified to the extent that a resolution such as this is capable of being converted into ordering council. And then so long, Mr. Swift says that the executive choice in terms of the ordering council is reflective of the content of the Security Council resolution, then that's a matter for the minister. And if that is correct, it would be difficult to see how a Wednesbury challenge could get off the ground. But we stick with our argument based on the limiting principle, based on the principle of legality and the presumption against blank check legislation. Mr. Swift submitted at one point, spent a great deal, well, he didn't spend a great deal of time on it. He said that the principle of legality has to be linked to an interference with fundamental rights, and he made the broad submission that property rights don't qualify. Well, with respect, we don't see how that can possibly be the case, and we're looking here at an interference at the most absolute level, the complete denial of any form of economic self-sufficiency to an individual, and the rendering of that person's entire life economically and all interactions to be controlled by the state. And it may be that my own friend doesn't take that point very far. He made reference to the Southern Rhodesia order in Council on the back of this irrelevant Security Council. He took you to Article 9 and raised questions, and this was really in the context of the reasonable suspicion standard. We don't resile at all from the transposition point, the fact that to the extent that this procedure is used, there is not freedom in the minister to overreach, to go beyond that which the Security Council resolution has said. And insofar as he was relying on the content of the Security Council resolution and then looking at the order in Council with a view to saying, well, this shows that matters of legislative design are the same in both contexts. Well, this is covered by our limiting principle in any event. Our limiting principle accepts the legality, for present purposes, of such a form of legislation. And the question, and it doesn't really add anything to the question of whether using a standard of reasonable suspicion in the context of this particular form of order, the Terrorism Order 2006, is a lawful exercise of the Section 1 power. Could I... My Lord Phillips referred to Article 7.2. A and B, and the suggestion was that that must be an expansion beyond the strict wording of Security Council resolution, which refers to persons who commit or attempt to commit. And in my submission, that must be right, because the basis for designation is a reasonable suspicion basis, and yet the category in 7.2a is a different one. That does, we submit, reflect the point that the terrorism order is plainly going well beyond that which Security Council Resolution 1373 requires. In relation to the submissions on certainty, my own friend's point all the way through is that all laws are vague to a greater or lesser extent. They will all require legal advice to a greater or lesser extent, and they may all require court decisions to a greater or lesser extent to clarify the point. In our submission, there is something fundamentally different about Articles 7 and 8 in the form of criminal liability it creates, and that exists not least because of the concepts which are inherent in Article 7. The concept of acting on behalf of or at the direction of somebody else, or making something directly or indirectly available, has no clear analogue in the criminal law. One would only imagine having to draft the charge to somebody who's committed this criminal offence, that one would have to be using concepts of the defendant on a particular day on behalf of or at the direction of the designated person, provided economic resources. The very concepts themselves are not ones which are readily known to the criminal law, quite apart from the examples which we've revealed in the correspondence, to which no clear response was given. And my learned friend did not address the paragraph 31 point in Hashman, which is looking at context, and we submit that the principle that men and women of common intelligence must necessarily guess at the meaning and differ as to its application is a principle which, when applied to the potential reach of Articles 7 and 8, does fail a standard of certainty. My learned friend repeats the point that we misunderstand the nature of the licence, and he says the licence is not by way of interference. We say we don't misunderstand it at all. The fact that there's no challenge to any individual licence misses the point. The licensing scheme is said to be necessary and is recognised as necessary in order to avoid the scheme becoming completely impossible. In other words, it's there to leaven what would otherwise be a situation in which a person could not access any resources at all. And licensing in that context is a crucial part of the entire framework of this criminal regime. Licensing is said to be a way of avoiding criminality. And the situation is one in which you have to have a team of civil servants who respond to questions such as, is an Oyster card covered, can I accept cups of coffee, and so on, in order for the person to understand the limits of the law. And in our submission, bearing in mind the principle in Hashman of looking at the reach and the context, these provisions fall into a quite different category of difficulty of foreseeability, accessibility and certainty from the public order examples in Chorhair and Hashman. Dealing with the arguments on proportionality, my Lady Baroness Hale said that her principal concern was the family members rather than the designated person. Mine is both. And in terms of the proportionality arguments and the underlying reasoning in M, and I'm thinking particularly of paragraphs 15 and 16, the underlying principle there was a concern that the restrictions on the ability of the family to spend state benefits without a Treasury licence was one which was simply disproportionate to the purposes of preventing terrorism in the context of the calibrated allowance of benefits to a particular group of people. And so it was not just a question of looking at the particular intrusions upon the family members as distinct from the designated person, the underlying concern that this measure was simply existing and operating at far too intrusive a level that could not rationally be connected to the legitimate aim of defeating terrorism. The reasoning in paragraphs 15 and 16 we submit apply with equal force to the proportionality of the 2006 scheme.
Doesn't it operate precisely as Resolution 1452 contemplates?
Well, the bottom line, and I rely on the exchange between Mr. Swift and Baroness Hale, both for the certainty issues and the proportionality points. But the bottom line, as I understand it, from Mr. Swift's position, is that the family as a whole need a licence to spend any portion of the benefit. And that must always be spent on basic expenses. So that's the requirement of 1452. Yes, but Mr. Swift says the licence is to permit the payment of the benefit to the family, but thereafter a licence is needed to ensure that only basic expenses are being dispersed. That's... Yes, Mr. Squires reminds me that the government then puts terms in the licence about how matters are to be spent. And I think Baroness Hale's example of what if the mother wants to save up a portion of the small amount that is there to save up for a slightly more expensive birthday present for the disabled child.
I think that's an example that we had in the evidence in...
Yes.
In M.
Well, I think on the face of it, that would not be permissible.
Just following from Lord Manson's question about the licence being, in effect, in line with Resolution 1452.
Yes.
Whenever your instructing solicitors raise a question with the Treasury as to whether something is within a licence or not, do they then refer it up to the Security Council Committee?
Well, they referred it up to the Minister.
Yes, well, I mean, I began to see some point as to why they said it had to go to the Minister, and one does think about sledgehammers and nuts, really, but...
Yes, yeah. Well, precisely, that we say that is relevant to the proportionality point. Whether the Minister had to consult the UN in order to give the answer, I don't know. But that was the document that talks about the fringe of a basic expense. And that's an impossible concept to work on. Now, could be said, well, that was a stupid answer to give, and it's not the right answer. But actually, in the light of that exchange, I'm not sure that it is the wrong answer, because these basic questions, which relate to the most mundane, everyday interactions, except to some extent these have been eased in the 2009 order. And no doubt the leavening of the impact of this regulation flowed from some of the debates in the M case itself. And I do rely on 2001 being one type of regime, 2006 being the absolute extreme regime, and then rowing back to 2009 for a number of purposes, but also, not least, for the proportionality argument. So we submit, and that's my final submission, that reference to the Bosphorus case and the seizure of an aeroplane as part of a sanctions regime is really not comparable. It's a wholly different context from the kind of regime that we are engaged in here, which is dealing with a regime impacting on individuals at the most basic level of existence and the ability to exist and make the most basic decisions about small amounts of money without state interference, and always at the risk that you may commit a criminal offence. My lords, my lady, unless I can...
Mr. Owen, can I just ask, I'm just not clear, it's my fault entirely, but I think Mr. Swift emphasised the preventive aspect of the Security Council resolution. I'm just trying to understand, supposing that the Treasury has got good evidence, which is good enough to create a reasonable suspicion that somebody is financing terrorism.
Yes.
Is there anything which you say that Security Council Resolution 1373 permits them or permits them to do?
Not via order in council, no. I mean,
There's nothing, but there's no requirement on them. There's nothing. It doesn't envisage them doing anything in that situation.
Well, no, it envisages ensuring that your domestic law is in such a state that it can comply with what 1373 is asking.
But that's what I'm asking. What does 1373 ask a state to do in a situation where it's faced, where it has reasonable suspicion that somebody is financing terrorism, but it can't prove it? Just it's got reasonable suspicion.
Yes, you're saying what does it call on states to do? Yes, it calls on them to set up a scheme which enables them to restrain assets.
I would have thought you said it doesn't call on them to do anything.
Yes, right.
Because all it's calling on them to do is to freeze the assets of those who are.
Oh, sorry, yes, no, that's what 1373 is doing. The subsequent resolution, the complementary measures, was suggesting a wider basis of reasonable cause to suspect. But in terms of what 1373 was calling, it was asking states to ensure that persons who commit...
So just after the 9/11 incident, the United Nations was adopting a resolution which didn't envisage you doing anything about people you reasonably suspect are financing terrorism.
Well, it didn't say that in the resolution.
The Special Recommendation 3 seems to draw a distinction between between freezing and seizing, and we were shown that, but without any very clear submission that I understood about what the status of Special Recommendation 3 is. That's page 421.
Yes, on page 409. Proceeds of, or used to, or intended to be allocated for use in financing terrorist or terrorist acts or terrorist organisations. So that invites focus on property that can be shown to be the proceeds of, or used or intended, which is similar to section 23.
But, sorry to interrupt, but just if one then looks at the interpretive notes at 421, it is saying, in effect, suspicion is good enough for freezing, but not for seizing.
Yes.
And whether that's right or not, who knows?
And 415 in best practices, paragraph 5, Roman 1, talks of development designation process which authorises the competent authority of the court to freeze funds based on information creating reasonable grounds or reasonable basis to suspect or believe such funds or other assets of terrorist related.
Where was that? Sorry, I'm not with you.
Sorry, page 415.
Right.
This is dealing with the requirement that jurisdiction should establish the necessary legal authority and procedures and designate council presupposes a designation system, lifting such freezing action, providing and then sets out how to take the following best practice. None of this is actually directly relevant to the question of what the word in Security Council resolution goes.
That's why I was asking you how you interpret it.
Well, I've interpreted it in the way that Mr. Forden developed in the context of the argument about whether reasonable suspicion was going beyond that relevant also to the point about whether this is a resolution against the law via an order in council.
I thought Mr. Fordham accepted that you could actually freeze on reasonable suspicion, but by way of a temporary step en route to a prosecution. But do you not accept that?
No, I do accept.
Oh, you do?
It's a question of whether that can be the basis for, as one C and D have been used, to justify a complete permanent freeze on all funds, assets, and economic resources of a person on the
I thought yesterday, in answer to this question, you said you couldn't freeze until you got your conviction.
No, I accepted that. No, I didn't make that submission. I referred to the restraint provisions, the civil restraint provisions, which were repealed by the Anti-Terrorism, Crime and Security Act. They were there in the 2000 Act, and they are now appearing in the ACTSA. Those are restraint powers, which are conventional restraint powers.
That's under legislation.
Yes. Yes.
Dealing with
The point.
Could you have done this by ordering counsel? I thought you said no, you couldn't. The ordering counsel is focusing on somebody who has committed.
I'm sorry, I'm being told my mic has been switched off. I'm sorry, I'm confused now as to what I'm being accused of having said yesterday.
There are three possibilities.
Yes.
One is the ordering in council permits legitimately permits freezing on suspicion.
Yes.
Secondly, permits freezing as an interim measure when you're setting out to prove the commission. The third possibility is that the only legitimate thing you can do under the Security Council resolution is to freeze once you've got your conviction.
Yes. My Lord, I intended, and if I didn't, I'm sorry, I intended to go only as far as the last proposition. What I was saying yesterday and acknowledging was that there clearly is already in domestic primary legislation a power to freeze or restrain in anticipation of prosecution, and thereafter, upon conviction, there's a confiscation power. And I was making the point that when Parliament has addressed those powers, it has tightly focused them on the funds themselves which have been used to commit the offence or which are intended for future use. I certainly hoped I'd made clear, consistently with Mr. Fordham's submission, that you could not, on the back of 1373, make, by order in council, the kind of order which the Terrorism Order 2006 is, which is a permanent freeze on the basis of reasonable suspicion.
But you do accept that there might be a temporary, I mean, this is what we're getting at.
Yeah.
And I still haven't understood your answer. That there might, even under 1373, be a temporary situation where you might have a short-term freezing order pending a proper proof that somebody was indeed a terrorist.
No, my submission...
You don't even accept that?
No, I don't accept that.
Right.
Doesn't.
Doesn't. No. Got it.